This is a current trends case brief on Club Resorts Limited versus Van Breda, which deals with the question of a real and substantial connection in the assumption of civil jurisdiction by Canadian courts in matters concerning conflict of laws. The citation is Club Resorts Limited versus Van Breda, 2012, SCC 17. Throughout this presentation, I will be discussing the facts, issue, decision, rationale, analysis, and also asking a survey question. In two different cases, individuals were injured while on vacation outside of Canada. The first case involved a young woman named Morgan Van Breda who suffered dreadful injuries as a result became paraplegic on a beach in Cuba. The second case involved a family doctor and father, Dr. Claude Charon, who died while scuba diving, also in Cuba. Legal actions were brought in Ontario against numerous parties, including Club Resorts Limited, a company incorporated in the Cayman Islands that managed the two hotels where the incidents took place. The accused challenged these proceedings by arguing that the Ontario courts lacked jurisdiction and, in alternative, a Cuban court would be more appropriate forum on the basis of the doctrine of forum nonconvenience. In both cases, motion judges held that the Ontario courts had jurisdiction and that an Ontario court would be more appropriate. The two cases were heard together by the Ontario Court of Appeal, where the appeals were dismissed. Both cases were subsequently appealed to the Supreme Court of Canada. Issues 1. Were the Ontario courts right to assume jurisdiction over the claims of the respondents Van Breda and Charon and over the appellant Club Resorts? 2. Were Ontario courts correct to exercise its jurisdiction and dismiss an application for a stay based on forum nonconvenience? Decision. In a 7-0 ruling at the Supreme Court of Canada, both appeals were dismissed. The court affirmed the real and substantial connection test as an appropriate common law rule for the assumption of jurisdiction over a certain claim. Justice LaBelle emphasized the importance of establishing a set of specific presumptive factors outlining when the assumption of jurisdiction is appropriate as a regime purely based on individualized judicial discretion. In a case concerning a tort, the following factors are prima facie, entitle a court to assume jurisdiction over a dispute. Justice LaBelle also outlined the following facts to guide the analysis of the court's application of the doctrine forum nonconvenience. Rationale continued. Issue 1. The Ontario courts have the right to assume jurisdiction over the claims of the respondents Van Breda and Charon and over the appellant Club Resorts. In the Van Breda case, a contract was entered into in Ontario. The existence of a contract created in Ontario which is connected with litigation is a presumptive connecting factor, which entitles the courts of Ontario to assume jurisdiction. The Club Resorts was carrying on a business in Ontario, which is a presumptive connecting factor. Its commercial activities exceeded promoting a brand and advertising. The company benefited deeply from having physical presence of an office in Ontario. This further establishes that a presumptive connecting factor applies and that the Ontario court is a prima facie entitled to assume jurisdiction. Due to the fact that Club Resorts failed to rebut these presumptions, the Ontario court has jurisdiction on the basis of the real and substantial connection test. Issue 2. The Ontario courts are correct to dismiss the issue of forum nonconvenience from the defendant Club Resorts because they have failed to show why the court should decline to exercise its jurisdiction and displace the forum chosen by the plaintiff. Club Resorts failed to show that a Cuban court would be a more suitable forum. Although a connection exists between Cuba and the subject matter of the litigation to support an action there, issues related to the fairness to the parties and to the efficient disposition of the claim must be considered. A trial held in Cuba would present serious challenges to the plaintiffs. For this reason, an Ontario court is the more appropriate venue. Analysis. The Supreme Court's dismissal of both Van Breda and Charon appeals can be justified. In both cases, the plaintiffs demonstrated an establishment of presumptive connecting factor. In Van Breda, a relevant contract had been entered into while in Ontario. In Chiron, the defendant carried on business in Ontario. The defendant in both cases failed to rebut the presumption, which justified an Ontario court is prima facie entitled to assume jurisdiction. For the reason that Van Breda became paraplegic and the Chiron family faces financial and emotional burdens of losing a loved one, there is a greater inconvenience to the plaintiffs of transferring the litigation to Cuba. This is a just reason to dismiss the issue of forum nonconvenience. The impact of this case. It looked at the real and substantial connection test. The test itself was not new, but there was some uncertainty over the factors. The Van Breda decision standardized the test with the 4 presumptive connecting factors, which made the test simpler and more objective. This case confirmed that foreign companies that reside, conduct business, or enter into agreements in a Canadian province will be subject to its jurisdiction unless they can rebut the presumptive connecting factor or include exclusive forum or arbitration clauses in their contracts. Analysis continued in relationship to other cases. The Supreme Court applied the same refined real and substantial connection test and guidance on the test for forum nonconvenience in 2 defamation cases on the same day. Survey question. Do you believe that the current 4 presumptive connecting factors in context of tort claims were adequate enough to make a decision for this case?